Afternoon, everyone. We'll be getting started in a few minutes. We're just waiting for some more people to log on. Everyone is in listen-only mode, so it's just going to be the administrators who are able to speak. So hold tight for a couple of minutes. We'll allow a few more people to sign on, and we will join you in a few moments. All right, we'll get started now. I'll just go through the preliminary matters as more people join us on our webinar today. We should have a very good attendance. I believe we have well over 1,000 people registered to attend today. So it should be a very good grouping, and it's a very diverse group who will be on this webinar today, a mix of excavators, members, potential project owners, and stakeholders from a broad range of different groups in different parts of the province. So we're very happy we have a very diverse group of participants today. And we look forward to talking to you about the work of the Dedicated Locator Working Committee and the work that we've done over the last several weeks. Just to give you a bit of background, I'll start by introducing myself. My name is Ben Hamilton. I'm the Executive Director of Ontario One Call, and I'm one of the members of the Dedicated Locator Working Committee. So I'll be presenting on their behalf today, but as I'll emphasize throughout this presentation, that the work is really the product of the group, and the group itself is very diverse, brings a lot of experience and different perspectives to the table. And I think we're the right group to start to bring this dedicated locator concept as described in Bill 93 to fruition. A few administrative things to go through. First, just in terms of the operation of the webinar, you may ask questions throughout the webinar through the question feature that should be on the top right-hand part of your screen. At least I am. I'm just presenting through an iPad today. So if you find the question mark icon, you can press that and ask a question. I will stop frequently for questions during the presentation and ask Adam and Ian from the One Call team to pose the questions that have been asked by participants. We may not be able to get to all of them, but Adam and Ian will ask the most frequent or reoccurring questions. With that, I'll ask people to ask questions just on the topic that's currently being discussed. Because we'll stop several times, there's no point asking a question about something that happened half an hour ago or that you think we'll discuss half an hour from now. So keep your questions to the specific topic that's currently being discussed. Also focus your questions on just topics around Dedicated Locator and the topics presented today. If you have questions about ticket suspensions or why your login doesn't work, or you have a question about something specific, there's other channels to ask that. We just want this to be focused on the work of the Dedicated Locator Working Committee. With some other questions, will this presentation be posted? Will these slides be available? The answer is yes. You will see a link to a dedicated webpage where all that information will be posted after this presentation. The key website for today's presentation, if you want the background materials, and most importantly, want to provide feedback, is ontarioonecall.ca/DL. At that website, you'll find a number of the background documents. You'll also find the materials from this presentation posted once we're completed this afternoon. And above all, the survey that we're asking all participants to fill out. The DL working group has been meeting for several weeks. but we still want and need a lot of high quality feedback from the participants on this call today. So one of the key takeaways is for everyone who's joining us to fill out that survey after reviewing those documents. And an important proviso as well, this is a presentation developed by the participants in the DL Working Committee. Not everyone has the exact same view on all these matters. There's a diversity of view amongst different people. That's normal and that's fine, but I do want to emphasize that what you're seeing is the best views and the best work of a group of people. It doesn't necessarily resemble the final decided product. So there's still opportunity to weigh it and share your views, and the committee is open to all of that feedback. On the next slide, again, important to provide your feedback. OntarioOneCall.ca/DL is the link where you'll find that feedback form. We'll have a period of 2 weeks to provide feedback, so some may wish to do it right away. Others, if you wish to talk to other people in your organization, take some time to review the background documents. You have 2 weeks until we're closing that feedback survey, so there's plenty of time to consider and discuss further. There are a number of documents there that you can review. There's a draft standard agreement between a dedicated locator and a member, the format of the 90-day notice, which is an Excel document, and there'll be some other background documents there, as well as the materials from today, which we will post later on. Once the consultation period is closed on May 20th, that information will be collected and shared with the DL Working Committee, and the committee will meet again in late May to review the feedback, make changes and additions, and also think more about the future governance, about how we're going to work as a committee and as an industry as a whole to further refine and improve policies and procedures around dedicated locator. There is still a lot of work to do. A lot of people have a lot of questions. We do have some of the answers today, but it is going to be a process to further understand how to best deploy dedicated locator and how to maximize its benefit for all construction work in Ontario. So on the next slide, how did we get here? A lot of you will have joined our previous webinar, which again had an attendance of over 1,000, where we talked about the introduction of Bill 93 and what was included in Bill 93. Dedicated locator was probably the central item in terms of operational improvements the government looked to make. That legislation moved very quickly. It was introduced in March 2022 and became the law in April 2022. So only about 5 weeks from introduction to passage. I won't spend a lot of time reviewing Bill 93. If you have questions about Bill 93, now's the right time to ask them. But in anticipation of Bill's 93 passage, the Dedicated Locator Working Committee started meeting in March 2022 to get a start on policies and procedures around dedicated locator. We did not want to wait until legislation was passed and then try to start from scratch. What the stakeholders decided to do was to take the momentum that was created from the Locate Solutions Working Group, which is a similar but different body, who met late 2021. They wanted to continue that momentum and use a similar process to get a head start to make sure that dedicated locator had some shape and form in anticipation of the legislation being passed. So we didn't want to wait and then be flat-footed when the bill passed. We wanted to get a running start. On the next slide, the committee membership, those of you who are engaged with the Locate Solutions Working Group, some of these names are very familiar, some of them are new. There is some overlap between the two committees, but they did have very different mandates. The Locate Solutions Working Group, looking at a broad range of improvements, including compliance, including operational procedures, including legislative frameworks and bylaws. This committee is mostly focused on the logistics of dedicated locator, what a dedicated locator model should look like with Bill 93 passed, and the policies and procedures required to animate that new power. So that's the committee membership. As you see, a mix of members and excavators, locate service providers, representatives from the One Call Board of Directors, and stakeholders as well. So a diverse group of members. And then on the next slide, you can see the topics that they worked on. And we'll go through these in order today. The definition of dedicated locator is where we'll start. Then we'll go through some key foundational pieces, such as a standardized template for members and dedicated locators, the format of the 90-day notice, which is a requirement of Bill 93, thoughts around training, certification, and QA for dedicated locators, which is a key issue, which we'll talk about at some length today, and then some other associated issues as well: record sharing, mapping, legal liability, and access to one-call records, and visibility into upcoming tickets. These are the 8 topics that the committee brainstormed and refined together, and these are the 8 topics we'll review today. With the definition of dedicated locator. So this is the one part of the presentation where we'll talk about Bill 93. So this is where you should ask your Bill 93 questions. Bill 93 provides a very specific definition of dedicated locator. And a lot of people coming into Bill 93 had different views and different concepts of what dedicated locator was. They thought it applies to only certain types of projects or to certain types of excavators, and that other ideas such as self-locating were entirely different types of concepts. And yeah, they are different and they can be used in different scenarios. But Bill 93 takes all of those different views about what dedicated locator and self-locator are and bring them under one umbrella and calls it dedicated locator. So the dedicated locator that we'll discuss in the context of this presentation is the Bill 93 concept, where all of those different beliefs and ideas and uses of dedicated locator and self-locate are smushed into one term. So what is dedicated locator? Bill 93 lays out 3 things that are dedicated locator. First, the designated broadband projects from Infrastructure Ontario must use dedicated locator. Second, the Minister of Government and Consumer Services may make a regulation requiring certain excavation, dig projects, or types of work to use dedicated locator. So the minister may do a regulation where it says all work of type X must use dedicated locator, just like the designated broadband projects. The third is an excavation or dig project where the project owner chooses to use dedicated locator. This is included to keep the ability to use dedicated locator very broad. And this covers what people typically think about as dedicated locator and also what people think about as self-locate. So literally any scenario where you can imagine a dedicated locator resource being used, whether it's the project owner requiring it or the excavator using it as part of their normal business and essentially charging the project owner for it through the normal bidding process, or if the project owner is willing to pay for that incremental cost, all of those concepts now fall under the dedicated locator umbrella. And as per Bill 93, all members must participate in dedicated locator. So current scenarios where excavators and project owners use dedicated locator, but only some members will participate while other members are not willing to participate or not willing to engage, Bill 93 eliminates that. All members must participate in dedicated locator. And that is a change that is hardwired into the Act. So essentially, the dedicated locator, again, is amalgamated under Bill 93 to include all those different terms and concepts. And it's written in a very broad and permissive way in order to maximize the potential use of new locating models. We're going to look at a couple of different scenarios later on in this presentation, but the key point to emphasize here is that the door is wide open for new ways and new ideas about how dedicated locator models can be applied. So I'll stop here and ask Adam and Ian if there's any questions from the group that they would like to pose.
I do have one here for you, Ben. It's when are the key parts of Bill 93 going to be proclaimed as a legislation? Things like dedicated locator seem not to be in effect until proclaimed. Is that correct?
I did check that with the ministry, and their view is that everything is proclaimed and in effect currently. The only exceptions being the things that require a minister's regulation. So as we mentioned, the minister has the regulatory power to require certain types of work to go into dedicated locator. That's not been used yet, so that specific power is not in force. The minister may make regulations around AMAs and financial penalties. That hasn't been done yet, so that's not in force. But otherwise, the ministry has advised that everything is proclaimed and everything is in force.
Ben, another question for you. There is some confusion around Bill 93 and the use of broadband as it's been stated in Bill 93. Is Dedicated Locator only for broadband projects, or is it for other projects as well?
It can be for any project where the excavator and the project owner wants to use dedicated locator. So it is not limited to broadband. If a project owner and a excavator are doing a road restoration, if they're doing a landscaping project, if they're doing construction of a new subdevelopment, all of those scenarios allow for the use of dedicated locator. So it is written in a way to allow the broadest use of dedicated locator across any type of project in any part of Ontario under pretty much any type of circumstance.
Okay, and another question is, what about large projects that started before the bill passed? Would they qualify for dedicated locator and be grandfathered into the new model?
I imagine that there's nothing preventing an existing ongoing project to say, we want to switch over to dedicated locator for our future locate requests. So I don't think you just want to switch the existing tickets, but I don't see a problem in a multi-year project that started maybe in 2020 and goes till 2024 saying, okay, we now have dedicated locator options. We're going to use dedicated locator for our future locate needs. So they're not somehow bound because they started before Bill 93.
That's great. Another question, Ben. If there is a project owner that is not working on broadband and they want to use dedicated locator, are all the members of Ontario One Call still required to participate?
Yes.
Great. And there's someone asking about broadband projects in general. Are they obliged to use the dedicated locator model, or are they able to go the conventional route?
So if you're one of the very specific designated broadband projects from Infrastructure Ontario, and that's a very specific term with a very specific meaning, you must use dedicated locator. If you're doing other types of broadband projects, which are not those very specific IO designated projects, it's optional to the project owner whether they want to use dedicated locator.
Another question here, Ben. Is the intent to only have one locator cover all utilities for the dedicated locator project? And then a second question within the same one, or is it going to be the utility owner that will be supplying each of the locators?
That's something that is developed in terms of how the business model works. I think everyone, when they talk about this model of dedicated locator, it's one locator doing all of the locates. The only exceptions to that will be the exemption in Bill 93 for transmission infrastructure of hydrocarbons. So that would be a scenario where you'd have a dedicated locator doing all of the locates, except let's say you have a natural gas pipeline. That locate would not be suppressed, and the normal locator from that pipeline company would come and do the locate. So it's essentially de facto a one locator scenario. with only that one wrinkle of the hydrocarbon pipelines.
I have another question. One more question. Sorry about that, Ben. Just a question about how Dedicated Locator also fits into our overall act. The question is, will the Dedicated Locator model still work with federal agencies and or First Nations?
Yeah, so without giving a constitutional lesson, federally regulated entities are still required to participate in provincial laws and provincial regimes when they are matters within provincial jurisdiction. And construction safety and the specific aspects of Dedicated Locator are in provincial jurisdiction. So just like you can work for a federally regulated company, you have to obey the speed limit on provincial highways, you're obliged to follow the Dedicated Locator rules. With First Nations, Ontario One Call doesn't have jurisdiction over those, so they would not be compelled in the same way as federally regulated entities. So NEB regulated pipelines, I guess there's a new name for it now, but the former NEB regulated pipelines, telecommunications, those are all subject. Indigenous communities are a separate issue entirely.
Okay, and I have another question here about gas and hydro, asking, are gas and hydro utilities exempt from the Dedicated Locator requirement?
No, the only people who are exempted are the very specific entities who are cited in Bill 93. And this was an amendment they made in committee while the bill was being considered. So the Hydro One transmission infrastructure, an Enbridge oil pipeline, a Trans-Canada pipeline, those are the only things that are excluded from Dedicated Locator. So natural gas distribution has to participate, electricity distributors must participate, all other infrastructure owners must participate. So let's move to number 2. So having described Dedicated Locator is very broad and very open, and one where members essentially in their entirety are required to participate, let's talk about some of the logistics and policies and procedures. One key deliverable the committee identified was the need to have a standard form of agreement between Dedicated Locators and members. There are over 800 members in the Ontario One Call system, around 400 municipalities, dozens of electric utilities, and an incalculable number of small entities out there. It would not make sense to expect a Dedicated Locator or a project owner to go out and talk to 10 or 12 or 20 individual members and negotiate 10 or 12 or 20 legal agreements from scratch. Also under the legislation, there's a very strong expectation that this will happen quickly. The legislation specifies a time period of 10 days. So without belaboring the obvious, we want to make this as easy as possible. And practically speaking, this stuff can't happen in 10 days. There's more legwork involved with that. It requires more lead time, and we'll talk about how more lead time is built into the legislation. But generally speaking, Dedicated Locators and project owners cannot spend years trying to make 20 legal agreements that are all unique with 20 different participants. That's why we need to have a standardized form of DL agreement that a member can take and easily adapt for their purposes for the Dedicated Locator. At the website link provided earlier, the onecall.ca/DL, you'll see a document that is the draft agreement. We won't review it today. It's a lengthy document. It's about 50 pages long, and it's developed based on the existing Locate Alliance Consortium contract. So those of you who are not familiar with LAC the Locate Alliance Consortium is a long-standing, it's basically a buying coalition. And it's a coalition of a number of utilities from all sorts of different sectors, and most of the large ones. And for a number of years and a number of cycles, they have been contracting essentially with dedicated locators. And so what the committee has done and the working group under it, they've taken the existing LAC contract and modified it so it can be easily customized by each member to meet their specific administrative and technical needs. In the interest of not reinventing the wheel, the committee's taken a well-known, well-established, and well-tested model and adapted it for use for other members. Within that agreement, a lot of issues that are obvious have been dealt with. Issues around legal liability, how maps are shared, insurance requirements, the technical standards for locates and how locates are drawn. All of those types of questions are dealt with in this agreement. What the working committee would want, and this is very important, a very important obligation under the law. My recommendation, the committee's recommendation to everyone today, is to take that document from the website, review it carefully, and also share it with your legal counsel as well, and tell them that under Bill 93, you may be required to have these types of agreements with new vendors, even if it's something you haven't done before, even if it's something you may not necessarily be comfortable with. This is a new obligation from Bill 93. And it behooves you to spend that time in advance with your legal counsel to ensure that you're comfortable with a form of a legal agreement, that if you want to make changes to it, that you make those changes in advance and you have that agreement ready to go, and that you've thought through as an organization the various legal aspects that are included in signing the DL agreement. Under the law, there's no real provisions to refuse a dedicated locator, only what is a reasonable thing to say this person is not qualified to do. And we'll talk later about what makes someone qualified to do locates. But unless you have a very specific and very justified reason to say someone should not be doing locates for dedicated locator, you are obliged to sign that agreement. We'll talk more about that in detail because that's a really important concept. But the short version is that this is something you'll be compelled to do. Under the law, failure to do so would lead you to be fined by Ontario One Call. So there are financial consequences if a member takes the view that we just don't like dedicated locator and we're not going to play ball. That's a scenario under the law where the member would be fined. We'll talk more about that in some detail in a few slides, but that's what's at stake. So that's why I really want to elevate the importance of this draft document. And that's why we feel it's really important that you review that document closely and you review it in your organization with your senior management and with your legal counsel so you fully understand what's being proposed. And of course, provide detailed feedback through the feedback form at the same web link. Any questions there from Adam or Ian?
Yes, I do have one for you, Ben. There's a couple of people asking about liability and who that would lie with. Would it be the member of the owner of the underground infrastructure, or would it be the dedicated locator completing the markings?
So the contract talks about that in some detail. Generally speaking, the rules around liability are the same as current outsourcing contracts. Errors relating to the mapping or records that the member have provided, that's the member's liabilities. Errors around the interpretation or the mechanical locate are the locator's fault. And again, there's a lot more that goes into it, but it's pretty much the same as any existing outsource agreement.
Great. Ben, another question here. Is it the project owner's responsibility to get the records from the utility owners, or does all that go through One Call?
So the utility owner is obliged under the Act to provide that records to the dedicated locator. That's a responsibility that's put on the member's shoulders.
We have a question about private locates and if that would fall under the responsibility of the dedicated locator as well.
So private locates, and we'll talk a little bit about private locators later. Private locates are really something different. They're locating infrastructure that's not typically within the one call framework. One call is responsible for infrastructure in the public right of way. Private locates typically deal with locates on private property. So that doesn't necessarily get rolled into it. There's a bit of an overlap, of course, because one call provides notifications for infrastructure on private property in many cases, the most obvious being electric and gas utilities in many scenarios, but private locating is really a separate process that's separate from dedicated locator and still exists as a need.
Another one here, Ben, about the billing of it, and I'm sure you'll get into it in a second, but is there additional billing that a member can do just for providing documents to their utility infrastructure?
So the law makes it very clear that the dedicated locator will be paid by the project owner. I don't think the law talks about any kind of other fees or administrative costs for that. I'd have to check further, maybe consult with the ministry, but I don't think the law talks about that scenario.
Okay, there's a question about the locate companies and if we have a list to provide today, or will we be providing a list of the locate companies in the near future that will be able to be used?
That's an ideal state we want to get to. We're going to lay out a few scenarios in the next few slides where we talk about what's sort of ready to go now versus where we want to be in a few years. But that's probably a future state. Essentially, there could be a list now, but it's going to be relatively brief. In the future, we would very much like to have a long list of many locators that project owners and excavators could utilize. But I don't think that's one of the things, we're not at that stage yet. We would like to be, but we're not at that stage yet.
Just another to follow up on that, Ben, there's a lot of questions about the standardized forms, when the drafts forms that they're going to be looking at right now and reviewing, when that will be ready to be finalized so people can start using these agreements. Do we have any indication about timelines?
Yeah, in terms of timelines, the broadband stuff, which is identified by the law, I know there's a number of project owners and a large number of projects that are being announced soon. I imagine that will be the first group of projects. And my expectation, though this is not confirmed at this stage, is that on July 1st, that'll be the first tranche of work to officially go into the DL program that exists under Bill 93. So I could imagine that in the coming months, so whenever these projects are announced, those project owners, and I think there's 8 of them, those project owners will start to approach members and say, hey, we're designated broadband projects. We're going to be using dedicated locator. This is our dedicated locator. You must now sign an agreement. So I would expect those conversations to start happening within weeks, not months. So if you're a member on this call and you know that you're likely to be in an area where some of those designated projects are happening, this needs to be a front burner item for you. And you should take that draft document and share it with your legal counsel and tell them, this is something where a project owner might be coming to us in the next few weeks for broadband. We need to think about what we would expect and what we would sign and how we would communicate our records and our expectations to the DL. So for a lot of people in this call, it's really a matter of weeks, not months, before this is a real issue. That's a good question.
And then just one final question for this section is, if the dedicated locator cannot keep up with the workload, are they able to subcontract out the work to a private locate company?
So the answer is probably yes, but that's really an issue between the project owner and the dedicated locator. And there's a bunch of issues, or a bunch of questions around like, well, what if the dedicated locator falls behind, or what if the dedicated locator is late? Those are all contractual arrangements between the project owner and the dedicated locator, it's for those two parties to figure out, just like any other two parties with a contract. So that's very different than the existing sort of the public model of Ontario One Call, but that's how that issue would work out. So the next slide, I feel I've already given people a lot of work and a lot of homework in the first half hour, but there's more to come. The format of the 90-day notice. So we've talked about a document that can be the template for an agreement between a dedicated locator and a member. So when you think of the process, let's say you're a municipality, there's broadband coming, and that's good news. What will you have to do? First step is to make that agreement with a dedicated locator. Once you've spoken to the project owner and you're comfortable with that dedicated locator. The next thing that happens is the 90-day notice. And this is a requirement under Bill 93. Essentially, the project owner must provide a rolling quarterly update of the work they're putting through dedicated locator. So every 90 days, and there's a form that is on the /DL website, which you can download and comment upon. There's an Excel spreadsheet, and this document must be updated and submitted every 90 days. The document contains a number of different tabs. What you see in the draft version is a typical one used for broadband projects. So again, it might be different if it's a different type of project. If it's a sewer and water project that's a much smaller geographic area, but much slower moving, it would probably look different and contain different information. But you get a sense of what is going to be asked from the project owner every 90 days. The document describes the geographic area of what's going on, the length, the area, also identifies the type of work going on, and other factors that can really help the dedicated locator understand the scope. It also serves another purpose. One blind spot is that if you're doing a broadband project in a certain municipality, no one knows exactly what members are in the proposed excavation area other than Ontario One Call. And One Call can determine that by looking through their mapping. So this 90-day notice also allows Ontario One Call to identify all the members in the infrastructure who have infrastructure in the proposed area. And then One Call, in its typical role as the hub, will share with the project owner the members in the proposed excavation area, and will also inform those members that there's a request for DL work in and around the vicinity of their infrastructure. So let's say there's a small telecom that no one's ever thought about. How are they going to be identified? They'll be identified through this process. So the project owner submits the 90-day notice. One Call analyzes the 90-day notice, identifies all the members, including this small, relatively unknown telecom, and it communicates both to that telecom and the project owner that they need to be in touch to have a DL agreement. So that's an important function of this 90-day notice. And it contains a number of fields that will be required, everything from the number of contractors, to the number of meters, to the speed and rate of the excavation. So for broadband projects, this will be large areas moving very quickly. For different types of projects, it'll be smaller areas moving very slowly. But this is the format for actually expressing what's happening and how much work it requires. And with this format, what happens is that the dedicated locator can properly plan the resources they need to meet the expectations of the project owner. So this is really the document that the project owner provides the DL to ensure that it is adequately staffed. So again, it helps One Call, it helps the project owner and members get matched up with each other, and it also helps the dedicated locator understand what kind of resourcing they need to provide for this project over the next 90 days. And of course, you can provide information that has a horizon greater than 90 days, and that's even more helpful in terms of helping the project owner tell the DL what kind of resources they're needed. And at a higher level too, there's a real cooperative relationship between the project owner and the dedicated locator. They're vested in each other's success, and the project owner has an incentive to communicate clearly and effectively about what their needs are to the dedicated locator. So that's another key concept here. So questions about that from Ian and Adam?
Yes, sounds great. Just a question here about the 90-day process, Ben. Does this 90-day process through one call supersede any municipal consent process?
Yeah, they have to coexist. And of course, the golden rule is make sure you have your permit before you ask for locates. But this is a process that will exist alongside whatever other requirements they be, whether they be municipal planning, whether they be permitting. There'll be other requirements as well in terms of vital main standby. This exists alongside of all those. It doesn't supersede your need to fulfill a municipal process, for example.
Okay, great. And does the 90-day notice apply to major projects outside of broadband projects choosing to employ the dedicated locator?
Yes, everything that's dedicated locator is required to do this.
I have a question about ongoing projects and grandfathered in. Would projects that are currently going on be grandfathered into this process? Could they utilize the 90-day process now, considering the project's currently being worked on?
Yeah, I think if there's an ongoing project and they want to transition over to dedicated locator, that would be possible. They wouldn't be excluded just because they've had previous tickets on the project. For future tickets on the project, I imagine logistically they could switch over to dedicated locator.
Sounds great. Another one, Ben, just quickly before Adam jumps in. We're getting some a whole bunch of questions about 90-day. Can you clarify if that's calendar day or business day?
Calendar day.
Okay, and there's one here about the 90-day notice, and is there a per notice or per ticket cap expected, i.e. no ticket greater than 150 meters?
Well, that's one of the good things about dedicated locator, which is you have the project owner / excavator working cooperatively with the dedicated locator. So yes, people should be mindful about how they enter tickets into the system. But the reality is that because the project owner and DL are working together, there's no real incentive to abuse the system or to dump tickets into the system. You can really get your locates when you need them with the dedicated locator. So yes, you should obey and follow all the existing protocols about the size of a ticket, but you can also work that out between the project owner, the excavator, and the dedicated locator, because in doing so, you're not really inconveniencing any other party. So the answer is yes, you should follow all the existing protocols, but there's also the benefit of that DL being the specific resource of the project owner.
Ben, we're getting a lot of questions about what if things change. So if the project comes into Ontario One Call with a 90-day notice, but then the scope of the project changes, the length of time, how much they need located, how does that work in this process?
So one of the reasons to have 90 days is because we know things change, and a lot of these projects are multi-year projects. But if it's something where there's been a change for what's happening in the next 90 days, it's important to communicate that to Ontario One Call, because if your excavation area has changed, you may be coming across members that you haven't identified yet. So let's say you're going north, you're going further than you thought you would, you're going north into a new municipality. There will be other infrastructure owners because you're in a different municipality. So you would have to amend those in terms of what you're doing for the next 90 days. So there's also a check that you'll see later on where One Call 21 days before will again verify the list of members. So if you're going to dig outside of the area you've identified, just like with a normal ticket, it's important you circle back with Ontario One Call to make sure there's no other infrastructure owners that haven't been captured in the original request.
Thank you, Ben. So do members get a copy of the 90-day notice through Ontario One Call?
Yes, we're basically going to, once One Call's identify all the members, we're going to send the 90-day notice to all of those members. So they should see everything that the project owner has submitted.
A question about relocates and 90-day notice. So would this 90-day notice system eliminate the need to relocate for a dedicated locator project?
So, you know, when you think about dedicated locator and you zoom out to 30,000 feet, I mean, one of the really good things about dedicated locator is that you have a project owner / excavator who's doing the work, and they're paying for the dedicated locator. So if there's locates, that's fine. If there's relocates, that's fine too. If there are daily relocates or unnecessary relocates or pedantic locates, that's okay too, because there is a locator and the excavator paying for it. So essentially, the locator can be as efficient as they want, or they can be as wasteful as they want. They're paying that resource, so they're incented to maximize the productivity of the locator. And that's different than the current model, where if an excavator is being wasteful of a locator's time, it's actually the members who suffer because they're paying for that. And it's other excavators who suffer because the inefficiency of that request harms the timely completion of other requests. Basically, dedicated locator removes the negative consequences of relocate or remark abuse, while also allowing the project owner and excavator to get whatever locates they want, whenever they want them.
I have another question here for you, Ben. Once a utility member has sent over their underground records to the dedicated locator, does the service member have any more responsibilities?
Same with Ontario One Call, you'll update your mapping as frequently as you update your mapping. And if the DL project is continuing, let's say it's a 3-year project for transit, for example, let's just use that as an example, you would send the DL your updated mapping or give them access to your updated mapping just as often as you would update Ontario One Call. So you do have a continuing obligation to ensure that the mapping you provided is updated.
I have another question, Ben. It kind of overlaps with another item that is in Bill 93. It's a question about sharing of locates. So if the dedicated locators are within the project area that someone else is going into, is it possible to share locates?
Yeah, that's specifically permitted under Bill 93.
I have a question about LSPs. And does the 90-day notice give the LSPs the ability to staff accordingly for the upcoming work?
That's a great question, and something that we've discussed at great length as a committee. Obviously, when you think about the timelines that are in the Act, so the Act talks about 10 days from when a member gets notice of a DL project to when they have to have done everything, including signed off on all the legal agreements and provided the mapping. That takes more than 10 days. Hiring and staffing and training dedicated locators, that takes more than 90 days. So everything you see in this presentation is informed by the idea that this needs to be done in a much more systematic way. There are parameters provided by the law, but as an industry, we need to be more systematic about it. So we're talking about periods where you work with your LSP a year before to identify the excavation areas and the members you need to have an agreement with. We're talking about providing 6 months notice of your specific excavation requirements so that they can hire and train and staff appropriately. So you see timelines that are 10 days and 90 days. Practically, we need to be thinking about, setting up the groundwork a year before so that when these legal timelines do tick in, your 90-day notices, your 10 days to complete a locate, all the agreements have been figured out, all of the workloads had been shared, all of the training has been done, and those things happen automatically. So yes, it's important to remember those 10-day and 90-day time periods, but you should be thinking about this in much more of a longer term horizon and doing the groundwork now to make sure that your projects for the next year can be successful.
There's a lot of questions, Ben, about is a request needed? And then is a request to Ontario One call for the actual locates themselves? Is that inclusive of the 90-day process, or is that outside the 90-day process?
So that process is out of the 90-day notice period. The process of actually providing locate requests to Ontario One Call through Dedicated Locator is exactly the same as it is now. So everything that you would do as a dedicated locator is exactly the same process as you would do for a regular member or regular LSP. You would submit your request to Ontario One Call. The notification is, for the most part, routed back to you. You have the mapping. You provide the mapping to the excavator so they can reconcile the paperwork with the marks on the ground. All of that process is unaffected. If you have to basically do stuff that's within the 90 days, if you're locating stuff outside of the identified excavation area, that creates a problem because you may run into members who are not originally identified. And when you put in that request and you get the ticket, you're going to see that there's a member who is not suppressed and who got the regular notification. So that creates a complexity. And that's why the dedicated locator can go on requesting whatever they want, except when they go outside of their planned excavation area as identified in the 90-day notice.
That's great. And just a final question for this section, Ben. What if the member has no mapping of their underground plants for the dedicated locator?
Okay. So if you're a member, and we know there's a lot of members like this, and a lot of them have communicated to government about their lack of mapping. If you don't have good records, or your records are outdated or limited, you're going to have problems with everything, not just Ontario One Call and not just Dedicated Locator. It's important that you as a member understand how you're going to provide information to a locator to provide these locates. If you're relying on experienced staff or institutional knowledge, that's not really going to be sufficient for the challenges ahead. Whether it's your one call requirements or dedicated locator requirements, it's also not going to be satisfactory in a number of different respects as well. So for those members who don't have that level of mapping, it's vital for one call reasons and many, many other reasons that you address that challenge and ensure that there's appropriate mapping available, even if it means a very manual process or an expensive process of constructing maps based on existing records and whatever detectable technology you're able to use. I know that's easy for me to say. Those things come with a big price tag, but your obligations under the law are very demanding, and there's a lot of reasons to really want to follow that process. So if you're not able to do locates currently or in a very reliable way, that's a challenge you're going to have to confront. You're not going to get exempted or treated differently under Bill 93.
That's great. Thank you, Ben.
So let's move to slide 4. So already we've seen two big documents to review. One is the standard agreement. The second is the form of the 90-day notice. And I think we sort of laid out some of the pillars that the committee has developed, but let's get into some of the meat of this. And this is probably the most challenging topic we dealt with, which is training and certification. Basically, who can be a dedicated locator? Members have all sorts of different views about who they want doing locates around their infrastructure. A lot of members, and I think probably the critical mass of members, have been outsourcing their locates for a while now. And they have a high level of comfort in outsourcing their locates, but they have a high level of comfort outsourcing it to LSPs that they know well, whose training and procedures they're familiar with, and LSPs who have a lot of experience providing QA, auditing, training. So they're comfortable outsourcing it, but to partners that they know very well. That's a good thing. That's a good basis to start from. And that's really the critical mass of members. There's still a significant number of members who do locates in-house. And for various reasons, some union, some just institutional, some, as the previous question mentioned, because their records are perhaps not great and it's best to have someone internal do them with perhaps some institutional knowledge, they do it in-house. That's something that Bill 93 changes. Bill 93 is premised on the idea that a single locator can do all this work. So for some people, this idea is in your comfort zone. For some people, it may not be in your comfort zone, but Bill 93 demands that everyone reach a level of comfort. So there's been a couple things going on here. Of course, there's a working committee with the DL working committee, of course, and also LAC as a separate body have been working on this as well. Obviously, we can't have a situation where any random person decides they want to be a dedicated locator and demands that members give them their records because they're employed by a project owner. There has to be some degree of standard and acceptable skill and experience level to be a dedicated locator. This is not the Wild West. This is a very difficult skill to learn. It must be done by a qualified professional. This permission can't be refused unreasonably. So what we have to do is create an acceptable standard about what's a qualified DL that members should be signing on to, and what's not a qualified DL, where the members are right to say, sorry, you're not at the right experience level, we're not going to certify you. There's a lot of challenges to this question. It's not easy to become a locator. There's not a lot of locating companies out there. There are high barriers to entry. It's a very specialized skill, and it's not the kind of organization you can set up overnight. As opposed to a lot of other businesses, you know, if you're opening a pizza place, low barriers to entries. If you're opening a locating service provider, it's much more difficult because there's a lot of equipment requirements, training requirements, QA requirements. It's a tough industry to get into. Difficulty of members certifying and monitoring new LSPs. Outside of LAC, most members either have one LSP or no LSPs. So the idea of having a bunch of different project owners with a bunch of different LSPs, all of whom have slightly different trainings and slightly different procedures and slightly different QA, even if they all follow your standards and procedures, that's challenging for them to manage and to think about. There's also fundamentally a lack of qualified locators out there. There is not a huge supply of locators who are available to do this work. It's an industry that has been challenged by the staffing challenges we've seen all across many, many different types of industries, and there's no easily accessible pool of locators to tap into. And last but certainly not least, there's no universal standard for qualification. The committee would have been a lot easier if we could just say, okay, you have to have graduated from this program at this college to be approved, or you have to have this certification, or have this standard approved. That doesn't exist in the industry. Even the LSPs themselves, we're talking about large, sophisticated companies here, even them, they have their own internal training and their own internal standards, but there's no objective external standards to say you're a licensed locator, just like you can hire a licensed electrician. So that makes it tricky. There's no easily understood objective standard. It's tough to get into the industry. Members aren't used to dealing with necessarily all sorts of different players. It's tough to get into it. So what's the outlook? Where do we start with Dedicated Locator. So the preferred method, and this is a starting point, this is an initial point, is to use existing LSPs with exclusively assigned staff to the project and set up separate entities within the existing LSPs. We're going to talk about a bunch of different scenarios in a second, but in terms of what the membership and LAC and a critical mass of members are comfortable with, they're saying use existing LSPs, set up big chunks of work with a big group of dedicated locators working on that project or projects, and set it up like that. What they don't want to get into is saying, here's 500 different locators who work for private locating companies or used to work for a major LSP and now put out their own shingle. The members really aren't super open to trying to certify a lot of small entities who don't have a track record, who don't necessarily have experience in major infrastructure in the public right of way, and who don't have well-established QA and auditing procedures. That said, it might be possible for those types of entities to work under existing LSPs and essentially be subcontractors. But the members aren't of the view that, at the start at least, they want to certify all sorts of small players. The complexity of the industry, the requirements for QA, for auditing, lends itself to a pretty sophisticated process where there's fewer participants. So we're talking about large companies or large associations. We'll talk about associations in a minute, as opposed to a large number of small fish with 100 different locating resources. So again, think of what will help the industry the most and what can be operationalized most quickly. The committee is thinking about big chunks of work with experienced excavators or excavator groups working with experienced LSPs with experienced and reliable training in QA, and having those big LSPs serving the big members on big projects. That's probably the best way I can describe the current view of the committee. Let's go through a couple scenarios where we'll unpackage this in more detail. Because like I said, there's a lot of different things that are opened up by Bill 93. Pretty much every scenario is possible. So let's take a look at some of those different scenarios and why some might work better than others, at least at this stage. So scenario one. I think you skip the slide, or you have to go forward one maybe. Yeah, here we are. So scenario one, a project owner is doing a project that starts in a few weeks and should last approximately 2 months. They and the excavator would like to use Dedicated Locator just for this project, specifically a company they're familiar with who currently provides public locates. Under the law, there's nothing wrong or prohibited about this. The door would be open for this type of scenarios. What the working committee says and what the LAC members would say, and the LAC members are just a group of large members. They don't speak for every member. But in terms of a lot of members, and I think this is both fair to say with those inside LAC and those outside of LAC, this raises a couple challenges. One, entities that provide private locates, a lot of them are very good and very skilled at what they do, but they don't have experience necessarily working in the public right of way or working with the diversity of infrastructure that a dedicated locator would have to do. They don't necessarily have the experience with liability and insurance that the existing LSPs do. And they don't necessarily have the type of QA or auditing power that they do. So right off the bat, even though there's a lot of positive regard for some private locators, they may not be suited for the type, the scope, and the liability of work we're talking about here. The other issue is probably a more fundamental issue, which is Dedicated Locator is really meant to take a critical mass of work off the existing base load and move it to a space where it can be resourced independently, and thereby reducing the burden of the system and allowing what you might call the baseload of locates to be done more quickly, but also in a way in which excavators and project owners can control the locating resource and get the important locates they need in a more timely fashion. And the benefit of that is that the projects will be done more quickly, it will improve productivity, and ensure that the benefits of these projects, for example, broadband projects, are enjoyed by citizens more quickly. So those are the multifaceted benefits from it. One of the key parts is that you really need to move large chunks of work to Dedicated Locator. And the idea that we're going to go through all the process of Dedicated Locator, for example, the 90-day notice, identifying the members, requiring the DL to sign contracts with each individual member in the identified excavation area, to do all that work just for one short-term project doesn't provide a lot of value to the industry as a whole. Again, this scenario is perfectly fine and perfectly legal under Bill 93. This is the type of thing that should be allowed and will be allowed, but it's not the best place to start. Scenario 2. A large contractor would like to have all their major work serviced by a dedicated locator in order to maximize their productivity. Many of their peer companies feel the same way. Their clients, the project owners, are supportive of paying the cost of dedicated locator because of the improved timeliness of construction. They're looking for a turnkey solution where the project pays the cost, but they do not have to recruit, train, or QA the locators. This is a scenario that's really in the sweet spot of the large consensus of members that the committee has spoken to. They're comfortable with this idea for a couple reasons. One, you're using the existing LSPs, so they've already approved the training, they're already comfortable with the QA, they're already comfortable with the procedures, they're already comfortable with the auditing. So when you use the LSPs that are known to the critical mass of members, that immediately eliminates a lot of concerns the members have. It's also as close as we can get to an official standard about what is undeniably an acceptable dedicated locator. For the project owners and excavators, this is also pretty desirable because it is the turnkey solution. We'll discuss a scenario where excavators and project owners can have their own locating resources. But when you think of excavators and where they're putting their time and effort, it's a huge undertaking to set up your own training capacity for locates. The overwhelming view of locators, and I can't speak for locators, but I think this is the consensus view expressed by them, is that they want their locates and they're willing to pay for locates as long as they're timely. But that doesn't necessarily mean they want to get into all the rigmarole of it. They just want their locates in a timely fashion. So this approach works for them as well. The other concept too is that it creates a critical mass of work that can be done outside of the existing base load. So imagine an excavator comes to a LSP who is well established, familiar with LAC, familiar with the largest members. Imagine that excavator comes to the LSP and says, we want to do this big chunk of work through Dedicated Locator on an ongoing basis. And we believe we'll have enough work for 15, 20, 25 dedicated locators on a yearly basis. And they go through the process of working with one call and actually sharing what that looks like. The LSP can then say, okay, if you want to use Dedicated Locator, we'll work on an agreement with you, and we'll set up that unit within our company, and we will hire and train and QA them just as we would any other locator. And all you have to do is pay the bill for those locators, and that resource will be dedicated to your work. That creates a win-win in a number of different ways. The excavator has that dedicated resource. The LSP is able to build up their strength as well. And the project owner also benefits from the timeliness of it as well. If you think about it from an industry perspective, so again, we're thinking about taking big chunks of work and moving them to Dedicated Locator. There's a lot of industries out there where you have several large entities who do millions of dollars of business, but probably look at their load and say, we're a big company, we do a lot of work, but maybe we only have 1 or 2 FTEs worth of locator work. And that work will be very haphazard. Some weeks it'll be very busy, some weeks it'll be very slow. Is Dedicated Locator for us? Are we excluded from this? I'd say absolutely not. What I believe makes sense is that for similar companies who would benefit in the same way, so groups of road builders or groups of sewer and water main contractors, to get together and say, we have common interests and we could benefit in the same way from Dedicated Locator. Can we pool our work together and work with an LSP to build out a dedicated resource to meet all our locating needs? In which case you could have your dedicated group of locators and all of the different excavating companies and the project owners who use them can drink from that well. So there is an opportunity, not just for big companies, but for coalitions of companies to get together and try to pursue this scenario. So that's the one that I think is most in the comfort zone of members at this stage and at the committee at this stage. This is probably the best way for people on this call to start their thinking. And scenario number 3. And after this, we'll pause for some questions. I'm sure there'll be a lot of questions and interest on this. A project owner or excavator is very ambitious and wants to develop their own capacity to hire, train, and certify staff. They're willing to build in-house locating resources so they can take control and not rely on any external party for locates. They're comfortable with managing the liability that comes with essentially running their own LSP company. So members have a positive view of this as well. This is, if you know what ACON does, this is essentially what ACON does. At the same time, this is the type of program where there are very high barriers to entry. All big excavators, to various extents, do some forms of training. And some of them will utilize their own internal resources. Some will utilize external resources. But essentially running your own LSP is a huge undertaking. And that's definitely been stressed through the committee's discussions. ACON had the advantage of having the legacy QX company. They literally reabsorbed their existing locate service provider. So if there are entities out there who want to develop this, I think the membership is very interested and excited in that possibility. They also caution too that it's not just a question of hiring the trainers, but you also have to build out the training and the QA and the auditing. And you also have to build a track record that gives the members confidence. Plus the greater legal complexity and the greater insurance needs required with that. So I think a lot of people might be thinking about scenario number 3. It might make more sense to start with scenario number 2 and basically outsource the training and QA and insurance with a view to perhaps down the road creating scenario number 3. Scenario number 3 is not really an easy starting point, and it's a huge commitment financially and organizationally. And in any case, I think a lot of people will look at this and say, this is the kind of service that I would like my association to provide, or I would like a separate organization to provide. Again, thinking not just of your own project or your own excavating interests, but across your industry. Is there a different type of group we could form to provide this service to a large number of peer companies? So that's scenario number 3. I'll stop there and ask for questions from Ian and Adam.
Great, thanks very much, Ben. We covered an awful lot of ground there, and there are a couple of questions here. The first one is, can a member ask for their inspector to be on site to oversee the dedicated locators to make sure that the markings are correct?
Yes.
Fantastic, thanks, Ben. The next question is about regulating the training Has there been any indication that the government will regulate a training program, or is that something that Ontario One Call will do in the future for locators? And then is there anybody regulating the quality of the locates that are provided?
Yeah, so to answer the last question first, right now in terms of regulating the quality of locates, that's done through, just thinking of LAC. So the LAC service providers have inspectors who do QA work. I also know a lot of the members do their own QA work in auditing as well. So a lot of times it's the LSPs with additional auditing by members. In terms of the role that the government might play or associations might play in developing a standardized training, I think as an industry, that's something that's really important to give more thought and consideration to. My 2 cents, I don't think there's a consensus in the industry yet that is strong enough to go to the government and say, this is the approach and this is the standard and this is how it should work. If the industry can develop an approach which says this should be a provincial certification with these very specific rigorous standards, that would be very helpful. But I don't think the government's going to create that standard themselves. They will look to industry to develop that standard, and for the industry to say we're comfortable with this standard, it should be recognized more formally. I know in my discussions with the working committee, I don't think there's that consensus there. I think some people understand it's a mix of training and it's a mix of, in-field experience, but I don't think that strong view is there. Or CGA offers training through their DPT program. I think that's a couple weeks, mostly in classroom based. That's a nice program, but in of itself, it's not a standard as well. So I think there's more work the industry needs to do to identify a widely accepted standard. And at that point, they can come to the government and say, this is the standard we want you to approve. But that's a very important issue for, I think, all stakeholders.
Thanks, Ben. The next question is, who's responsible for providing the training and certification, and who would cover that cost?
So depending on the scenario, so with scenario 2, it's the LSP who does the training. It's the training that's been reviewed and approved by the members. And essentially, they're certified by that LSP because they've completed that LSP's training. And there's a lot more that goes with that as well. There's mentorship, there's shadowing, there's additional QA work that goes on. So essentially, the LSPs in that model handle all the training and certification and QA. With scenario 1, again, it's really up to the locator to do that work, which I think is one of the challenges because these locators, their training isn't well known or well understood amongst, the large group of members. And in the third scenario, you're really describing a very formal and well-established internal training procedures, which has likely been certified in some form externally by the members.
That's great, Ben. Question around the large LSPs. If the large LSPs are having some difficulty with the workload in the standard locates, and it seems that most members are comfortable with them at the beginning of this process, is there an opportunity for the smaller companies that want to get into this field to work with them directly, or should they be going to the members directly?
I would say there's a great opportunity to work as subs directly under the existing LSPs. The obvious question that comes from scenario number 2 is that the existing LSPs are already oversubscribed and overburdened with the existing workload. So how would they have suddenly 20 more LSPs to help me out? Well, the answer is that A, if you give them enough notice, if you talk about your needs now for future years, they have enough time to recruit. And if you provide them with a stable stream of work from your projects, they'll always be able to hire and retain those people. So there shouldn't be a lot of turnover. So that's a key part. You can work out an arrangement with an LSP that should hopefully ensure that resource is there and reserved for you and can provide you with a lot of continuity in your locates.
Okay, so I think we've spoken about this, but a clarifying question is that can the project owner hire and train their own dedicated locators?
They can, but again, if you think of scenario number 3, the one party that does that, which is Acon, they have an enormous amount of experience and essentially own their own LSP. That's a very high standard. So it's not only a question of the training. Are you going to have the QA required? Are you going to be able to do the auditing required? Do you have a track record that members would be comfortable with? All of that is an enormous financial and time commitment, and it takes years to build up that credibility. So I think members will be interested in project owners being able to build up that kind of competency internally, but it's not the kind of thing that happens overnight. It's the kind of thing that happens over years. So there'd be interest, but again, it's that thing with a high barrier of entry. So I wouldn't discourage it, but it's not the kind of thing you can do from day one.
Ben, I have a scenario question here. What happens if there's a project that comes in and all the members are happy with the training and the certification of one particular LSP, except for one who's had bad experiences with inaccurate locates from this LSP? How do they overcome that? Is this one member who is holding out going to be at fault or risk of compliance action?
So this is a difficult question, and the law doesn't necessarily give us a clear indication about how this should be handled. Ideally, it should be handled amongst the various participants, and ideally the dedicated locator would be able to work with that member to give them assurance or undertake any remedial action required to satisfy that member's concerns. That's the ideal scenario. If a member essentially wanted to veto someone because of prior bad experience, it's hard to say, and every circumstance would be different. If there was a long-standing set of issues, and I know those issues do exist with some utilities and some locators, then I think you would have to recognize that members who have a clear, demonstrated, and repeated reason not to rely on an LSP could essentially veto that. I think, however, that would be a pretty high standard. And I think the original expectation would be that the dedicated locator and the member had worked together to resolve any outstanding concerns.
Okay, thank you. So if a dedicated locator completes the locate and then the member goes out and audits it, but it fails their audit, does the member have any say in any correction action towards the locator?
Yeah, of course, don't forget that the member has signed a contract with the DL, and that contract specifies all the technical arrangements that are required. So even things like, some members have vital main standby. That's the kind of thing that would be dealt with in that contract. So it's not a case of the members just signing away their rights and responsibilities and sending it away. Members still have a role in ensuring the quality of locates around their infrastructure. They're not disenfranchised from that at all.
Ben, we're getting a lot of questions just about fees in general for dedicated locator, but this one comes back to, we're a small company that would like to get into becoming a dedicated locator. Do we know what kind of fees will be established? Is there a set rate so they can recoup their costs and see if it's something they want to do as a business option?
Yeah, I don't think that's really been fleshed out yet. I think that's still subject to discussions between project owners, excavators, and the DLs themselves. The way it should work at a very high level, and the law doesn't really get into that, by the way, either. What should happen is that the project owner who's responsible for paying the DLs, it should be lucrative enough that whatever costs the DLs have, it still remains a profitable business to be in. But that is an area where a lot of things need to be figured out, and a lot of that will just come from the market dynamics.
Okay, so Next question is about Ontario One Call, and are they thinking of developing a locator certification program similar to the plaque that's currently offered?
That's a question we've got before. Some people say One Call should do it. Some people think ORCGA should do it. Pardon me. Yeah, some people think One Call or ORCGA should do it. Some people think the private or the provincial government should do it. Other people think, different DAA should do it. I don't think it clearly rests with One Call. That's outside of our legislated mandate. ORCGA is an option. Pursuing something with the government's an option. Some people suggested maybe something through labor unions. All of those are options. I think it's just a case of the industry needing to think about it and identifying a preferred option. So I think everyone's ears are wide open, and it's just a question of who can take the initiative to press forward with developing a single source for a single standard.
That's great. Now, just a couple more questions, Ben. I have a question here that asks about if there isn't enough qualified and trained dedicated locators out there, would Ontario One Call limit the amount of projects coming through as dedicated locator from the broadband companies or other sources?
I mean, the legislation doesn't envision that. I mean, our job is to process requests. If there was a scenario where there wasn't enough dedicated locators, other than the mandatory projects, which are the broadband projects, or whatever else the minister determines, if there weren't any dedicated locators, they would just go on to the normal base load and they'd process like any other ticket. That's kind of the default position. But I think ideally we want everyone who wants to use dedicated locator to have the opportunity to use dedicated locator, because that's a scenario where both, the project owner and the excavator and the member should win. So I don't think that's what we would want to see, but in a scenario where there wasn't enough dedicated locators, we would just do it on the normal system.
Great, and just one final question for you on this section, Ben. Is the member able to request a copy of the completed locates from the dedicated locator?
Sure, that's something they can put in their contract with them.
Thank you.
So the next several items, I'm going to go through relatively quickly. I won't stop at the end of each of them. So here are another set of topics that the committee reviewed. They don't necessarily have easy answers. There was discussion around sharing records and maps between dedicated locators and members. We talked about the two primary platforms and how it's not necessarily clear that there's going to be a single standard. So I don't think it's going to be a question of, One Call or the industry saying, everyone get off this one platform and move to this other platform. I don't think that was really the view of the committee. If you feel otherwise, please let us know through the feedback tool. But at the very least, there was a view about what should be shared, which includes the as-built drawings, which I thought was an important inclusion as well as layers. So there's a view that there are some limitations here, but there are some minimum things that can be shared. On slide 6. Slide 6 really talked about legal liability, and there was a lot of discussion about the form of the contract between the member and the dedicated locator. I think this group's view was that everything that's out there in terms of legal liability should be dealt with in the standard agreement, and that in reviewing that document, if stakeholders didn't feel it was addressed satisfactorily, they should make that known through the feedback tool and the opportunity you have to provide feedback in the next 2 weeks. So it should be dealt with in the contract. If it's not, share your views, and perhaps we should amend that contract accordingly. On slide 7 is access to One Call records. So this is a general concern as well, or an item of general interest that our operations committee discusses at some length. And I won't spend too much time on this slide. So a scenario that we've discussed already in some of the Q's and A's are scenarios where a project owner submitted their 90-day notice and then something has changed. So one catch is that one call will audit that notice 21 calendar days before the start of that project, just to make sure that no other members have entered or installed infrastructure in that area. Just like normal locates, when you change the excavation areas, you need to get another request. If you increase the excavation area that you've identified on your 90-day notice, you need to resubmit to Ontario One Call, because if you're going further or farther than you originally proposed, you might be going into areas with members who haven't been identified in the original area. So that's an important process to develop as well. We want to make sure that we have protections in place to make sure that a DL does not come across infrastructure they hadn't already accounted for, and that we have a check in place to help with that. On slide 8. And this is an ongoing interest as well. So again, something the operations committee considers. And if you have feedback on this, please do let us know in the feedback. We have opportunities to provide feedback on each of these 8 topics. So in terms of the visibility into incoming tickets, so it starts with a 90-day notice. Of course, that's a rolling quarterly update to provide visibility into the scope of the project. The dedicated locator will provide all members and project owners with updates on the starting date, the requirement number, locate area, all those important features. The DL, and so this works exactly like an existing request. The DL updates the locate status through the 360 feedback tool. That does not change. And the project owner confirms with the members and Ontario One Call when the project is complete. Essentially ends the cycle of 90-day notices. So that's the process of how it works. In theory, this should matter less, because when you think about it, the project owner / excavator is paying the bill of the dedicated locator, and they can put in requests whenever, and it's up to the DL and the project owner to figure out their workload. So in one respect, they can do whatever they want. They're not really inconveniencing anyone but the dedicated locator who's paid for that job. At the same time, as referenced before, there are members who do want to be notified about work around critical infrastructure. Those will be included in their agreements with the dedicated locator. So if you have vital main standby, that's one of the criteria that you include in that contract. And so that will be addressed as well. So it's not just a question of, you put in requests and do whatever you want. You still have to follow all the policies and procedures, 360 feedback, and also working with members who have certain requirements around how their locates are done. Any questions on those few topics before we go to next steps and some general discussion?
There is one, a couple about the feedback in this. I know it's not specific to these sections, but I think it is good cover. There was one about the possibility to submit feedback that's beyond 1,500 characters in each of the items set out, or if there's any feedback that doesn't fall under the questions on the feedback form, is there somewhere that the listeners to this call today can provide that feedback?
Sure. That's a good question. I don't know who to send it to. You can probably just send it directly to me if you would like. It's just bhamilton@on1call.com. If you'd prefer to provide written feedback, like a formal letter or something along those lines, or if there's attachments or things you want to send as well, maybe examples you want us to look at, feel free to send them to me directly, and I'll ensure that they're collated along with all the other feedback and shared with the working committee. So if there's a different format or a different form you want to provide, feel free to do so. Send those directly to me, and I'll ensure they're included with everything else for the committee's feedback and review.
That's great, Ben. I'm getting a lot of questions about transmission lines. So if they're excluded from the dedicated locator process, does that mean they don't have any insight or any visibility to anything that's coming in, like the 90-day notice? Do they have to wait for the locate request?
Yeah, so that's something we'll probably give a little more thought to. I imagine that when we run into a hydrocarbon transmission or electricity transmission, I imagine we'll still notify that member of this project so they understand what's coming down the pipeline and can think about their own resources appropriately. On the tickets themselves, they'll get the regular notification. So I think we will likely include them in the notification that all other members get, just that they don't have to go through this process of signing a DL agreement if they don't want.
Okay, thank you. So it's been mentioned that a project owner or an excavator would be paying for the locate. Can you clarify which one is it? Is it the project owner or the excavator?
Yeah, that's a great question. Let me be super clear about this. The law is crystal clear. The project owner pays for dedicated locator. What that looks like practically might vary a little bit. Maybe they want the excavator to pay, and then the excavator bills the project owner back. And on a day-to-day basis, it's probably the excavator directing the dedicated locator more than the project owner directing the dedicated locator. But at the end of the day, the law is clear. The project owner pays the cost of dedicated locator.
Thanks, Ben. There's a lot of detail in the Getting Ontario Connected Act around dedicated locator about certain timeframes, the 90-day notice. People have also talked about the requirement of a 10 business day for the dedicated locator to get the locate complete. So what happens if these deadlines aren't met or someone refuses to use a dedicated locator? Has compliance been established? Will these parties receive fines?
So the quantum of the fines will be determined by a regulation to be developed by the Ministry of Government and Consumer Services over the next while. But yes, everything you described does create the risk that those members would be subject to financial penalties. There's also another process as well that was introduced in last year's Bill 257, which is a Building Broadband Faster Act, that was carried over into our legislation through Bill 93. And that's the concept that, at least for the broadband people, those broadband project owners could take members to the Ontario Land Tribunal for the financial impacts of providing late locates. And I'm not sure if it includes inaccurate locates, but that was also carried over to one call's legislation. So now members and excavators can take one another to the OLT for the financial consequence of providing late locates or providing inaccurate locates, or on the other hand, members can take excavators to the Ontario Land Tribunal for offenses the excavator has done under the Act, which are pretty limited and specific, but includes things such as digging without locates and digging in an unsafe manner. So the risks of not meeting the legal requirements do include AMAs, which are fines from Ontario One Call, but they also include this new OLT process, which includes both broadband stuff and other dedicated locator stuff and other stuff generally. So there is essentially a new concept of, in a way, but not exactly, double jeopardy. You could be fined from Ontario One Call, and on top of that, an excavator or member could seek damages from you as well. So there is greater liability that everyone faces because of what's come down with Bill 257 and Bill 93.
Thanks, Ben. Just to reiterate one thing, there's a lot of questions about feedback now that they're seeing all this. I just want to restate that there's an opportunity for everyone on this webinar to go to ontarioonecall.ca/DL, and they can provide feedback, and that's where we'll also post this presentation as well, so they have access to it. And just one more question, Ben, on this topic, including visibility. So if it goes through all this process, when it actually gets released from Ontario One Call to the dedicated locator or the member, will it be indicated on the notification that it is a dedicated locator project?
I think we'll refine this a little further in terms of what One Call's processes will be. but it should be clear from the ticket, from the excavator code, that it is a DL project. All the dedicated locator projects will have very specific excavator codes. So that should be identifiable on the tickets.
Thank you, Ben.
So we have 20 minutes left. So feel free to ask any additional questions or any general questions you might have. Just to talk about some next steps as you write those questions. As Ian just mentioned, go to ontarioonecall.ca/DL, complete the survey by Friday, May 20th. So don't feel you have to complete it in the next 5 minutes. You do have plenty of time to compose your thoughts. A second point, and this is very important, I know a lot of people in this call are involved primarily in day-to-day stuff around locates. And we do webinars about system changes. We do webinars about mapping improvements. We do all those webinars all the time. And this is different. This is different because Bill 93 creates very significant and new legal obligation on members. And it's important that you start to talk to other people in your organization about those. If we're announcing just a new system change, you're probably the only person in the organization who needs to know. But we're talking about new and significant legal obligations. We're talking about things that put new requirements on your organization and put some pretty serious timelines on it as well. So it's important that you take the time to review these documents and that you share them with senior staff in your department, in your organization. It's also important, if you're a member, to talk to your legal department. There is a new obligation imposed here. There will be an expectation that members are able to reach agreements with dedicated locators in a very prompt manner, and you could be asked to do so in a relatively short time frame. So it's important that you take that draft agreement to your legal department and you start a conversation with them about how you as a member would like to handle this. It'll probably lead to more questions and more inquiries. That's fine. But let's start this conversation now within your organization, as opposed to waiting until the day you get your first request and are under a timeline to complete it. So those are some important things that I hope everyone on this call does. So we do have some time left, and I'll ask Ian and Adam to pose any other questions they may have.
Sounds great, Ben. I think we'll probably do a rapid fire here with some questions. There's been a lot of questions about escalations and timelines. So what happens if there's an escalation with a member? Is there any leeway in the timelines that are in the Act currently for Dedicated Locator if they have to escalate things?
You mean escalate is like a specific locate and there's a specific problem with a specific locate?
Correct.
Yeah, that's actually something that was discussed within some of the committee discussions we've had. I think it's fair to say that, yes, there will be time to escalate that. And yes, there was a lot of discussion around what happens if a dedicated locator comes across something they're not familiar with or comes across a conflict with the written records. What should they do? And I think it's fair to say that the consensus view was that they should follow existing procedures to ensure that there's no conflict. So it was very much imagined that if a dedicated locator ran into something, they would be able to escalate within their own organization and escalate within the member the problem, and so it could be addressed promptly.
Okay, great. So when using or when wanting to use a dedicated locator, who assigns that dedicated locator? Is it through Ontario One Call, or do the project owners find the locator?
Yeah, so the law doesn't really get into the nitty-gritty about, is it the member's job to provide the dedicated locator, or does the project owner have to find the dedicated locator, or does the excavator have the dedicated locator? The law doesn't get into that. And the law leaves it to all those parties to figure out what is the best financial and economic model. So practically what should happen is that first off, your first stop should be Ontario One Call, just to help you understand the nature of your work. And if this is not just a specific project, the volume of requests that you typically provide. So One Call might be your first stop. Second, I think it's important to reach out to members and existing LSPs as well to get a sense of, first of all, to orient them to your project, and also to be put in touch with the right LSP who may be able to service you. I think that's probably the best place to start, but nothing is prescribed. It really relies on open communication between project owners, excavators, members, and LSPs. I know some people say there should be a list, and the members should provide a list, like a menu, and the project owners and excavators could just pick someone off the menu. I think that's a point we would like to get to. It's probably not a point we're able to get to right away. That's an ideal state, but right now I think it's more the a process of discussion and planning.
Great, thanks, Ben. With Dedicated Locator coming in, is requesting a locate through Ontario One Call still free?
Yes, it's by law, putting in your request on Ontario One Call is and will remain free.
And the next one's about the payment between the project owner and the dedicated locator. And will this be required on an hourly basis, a daily basis, or would this be decided between the two entities?
It will be decided between the two entities. You could pay them on a piecemeal basis. You could pay them on an hourly basis. You could pay their annual salary. You could have a cost plus basis. It's pretty much open to whatever suits the project owner and the excavator, and the project owner and the DL.
Ben, this is a comment on something that you had made earlier, and I just want some clarification. You mentioned something about compliance regulations, and then that will go into effect for Dedicated Locator. Can you explain that, or can you confirm that?
So under Bill 93, there's a couple of powers that the minister has that they can use by regulation. So that's typical of any law. Laws often contain a lot of detail, but then say the minister may make regulations to determine X, or the minister may make a regulation to determine Y. So amongst the powers that the Minister of Government and Consumer Services has under Bill 93, one of them is the ability to establish what the AMA regime is. So everything from what the financial penalties would be for late locates to what they would be for not responding or not providing mapping, all of those are going to be laid out in a regulation that'll come in the future. So those are something that the ministry is working on currently, and the actual specific penalties will be laid out in those regulations.
Okay, so with regards to Bill 93 and the timelines imposed by it, will the dedicated locators have a similar timeline for the turnaround of the locates from when they get notified from Ontario One Call?
Yeah, so both in Bill 257 and also in Bill 93, those projects are going to have a 10 business day limit as opposed to a 5 business day limit currently. Practically speaking, if you're a project owner and your excavator is leading the project and your dedicated locator is your dedicated resource, you're probably not putting in tickets into the system far in advance and then not getting to them for a month. There's no particular reason to do that. I would imagine that most tickets will be submitted and closed the same day, and that the excavator will be working with the DL on site to submit tickets and complete tickets all at the same time. So I imagine that while there is a 10 business day limit for those, I imagine practically it'll be pretty seamless between the excavator asking for something and the DL providing it.
That's great. Thank you, Ben. Lots of questions about the posting of this presentation. Just want to say again that we will post this to our website, and we will send out a communication as well through our e-blast list. Early next week, we're giving you all the links that you need just in case you miss it here. So we'll make sure to post that for you shortly. Ben, can you confirm the date that people can provide feedback on ontarioonecall.ca/DL on the process of Dedicated Locator?
Yep, so that survey will be there through Friday, May 20th. At that point, we're going to collect all the feedback that's been provided, and we'll share it with the working committee. So the working committee will meet again at the end of May to review all the feedback that you provide and go ahead and make some future changes, but also think about governance going forward. The committee knows that this is going to be a process that will unfold over time. They want to make sure that it's set up for success in the short term and the first few projects that come through, but they're also thinking about the governance of this longer term and how there'll be a form of constant supervision and review and improvement going forward. They want to make sure it's a success. They want to make sure that the various different scenarios and opportunities with Dedicated Locator are realized. And they want to make sure that when we look back a few years from now, we can say that DL unfolded in a way that was rational, that was helpful, and was prudent and safe to do so. So that's the view of the committee, and your input is going to be very important to the committee in terms of how they shape the next step. So above all, I encourage you to participate in that feedback by 2 weeks from today.
That's great. The next question is, can a dedicated locator get the records from Ontario One Call directly, or do they go straight to the member to get those separately under the signed agreement?
So they'd have to come from the members. The records that we have in Ontario One Call are not necessarily the same as the members have and that the members use for locates. What we have for members is what is the mapping required to generate a notification, which doesn't necessarily have the kind of detail or overlap that their actual records to do locates are. They're not necessarily the same.
Ben, why would a project owner want to use a dedicated locator model if the standard locates are still legislated by law to be a hard 5 business days?
That's a good question. That really gets into what's the market rationale for dedicated locator. The reality is this: we live in a province where there's strong increases in excavation activity. We've all seen that in our own businesses. We've seen all of our organizations, no matter who you are in the industry, stretched to the limit. And there are a lot of challenges with locates and getting timely locates. Yes, with the regulation coming from MGCS, there will be more rigor around 5 business days. But for project owners, the real question is this: do we want to rely on an external dependency for the timeliness of our project? Do we want to rely on a system where we put in a request and up to half a dozen different people are expected to come out in 5 business days and provide locates? And are you willing to take that risk when the cost of your crew being idle for a day might be $10,000, $20,000, or $30,000? Or does it make more business sense to say, I want to control that locating resource, and I want to remove that external dependency, and I want to make sure that while I might save a couple $100, while I might not be saving a couple $100 by trying to get a free locate, missing out on that small savings is worth it because I can maximize the productivity of that crew that cost me $10,000, $20,000, $30,000 a day. It's basically a calculation to say that it's not worth trying to save a couple $100 when I have 10 times, 20 times, 50 times that number vested every day in my excavation crew, and maximizing their productivity even slightly more than pays for that cost. It's really a question of economic productivity that makes dedicated locator an economic benefit.
Okay, great. Just a couple more questions. They're slowing down now, but For the excluded transmission operators, would the expectations be the same 10 days completion for a dedicated locator as it would be for the other locates?
Under our law, it is. Under different federal jurisdictions and federal laws and regulations, they may have different timelines. So practically speaking, for our purposes, they have 10 business days. I know a lot of them have shorter timelines dependent on their federal regulation.
Great, thanks, Ben. I have a two-parter question here. So maybe I'll ask it's two separate questions. Does the now law that was brought in about the locate validity being 60 days for all members, does that is that also a requirement for dedicated locator, or is there a different timeline?
Yeah, it's the same requirement for everything.
Fantastic. And the second part of this question, if a dedicated locator signs onto a project, can they ever refuse that project or refuse locating a specific member? And on the flip side, can a member ever refuse to accept dedicated locator?
So the last question first. For a member to say, no way I'm signing on to this dedicated locator, they would have to have a pretty well substantiated track record of bad performance by that LSP. They could not do that, light-handedly. That's a serious thing to do, and they have to have serious reasons to do it. Now, there are some members who do have that kind of track record with some LSPs. It is a high standard, but I know it could be met in some cases. Regardless, members and LSPs need to work together to address performance issues. That's a general point. And what was the first part of the question again?
Sorry, I just asked the question if could an LSP refuse after they sign a contract? Could they refuse providing that locate?
So there is a scenario. So here's a possible scenario. Let's say a DL is working in an area, and just as an example, I'll pick a random example, there's water transmission infrastructure in that area. If the dedicated locator said, I'm not really comfortable doing the water infrastructure or that water transmission infrastructure, and if the local municipality said, I'm okay doing that locate for you, we would basically take the water transmission off suppression, and essentially it would generate a normal notification that would go to the member, and the member would notify that if both parties were satisfied doing that. There might be cases where, we'll just stick with the same example, where the water transmission people say, you know what, we're not exempt from dedicated locator, but we really want to do locates for this transmission infrastructure. If the dedicated locator was okay with that, basically they could say, okay, we'll use dedicated locator, but we won't suppress the water, and we'll let you get and complete that notification as usual. So there are a couple of scenarios where there can be workarounds. If the dedicated locator and the member both agree that they're more comfortable with the member doing the locate, that's something that can be accommodated within the system. And it's also very clear how the notification works, who's doing the locate, who's liable for it. I could imagine some scenarios like that. I don't think there'll be many, but that is a possible scenario.
Great, and just one final question for you, Ben. Can a dedicated locator renegotiate dates with the excavator in the same way that they can currently do, or does the legislation negate this process?
Nope. All the renegotiation requirements continue. Of course, with Bill 93, that must be done in writing now, but that's still an option. As I mentioned before, in any case, it makes sense to only put in your request when you're ready to actually do the locates and do the work. There's really not going to be a scenario where an excavator should put in a request a month before and then they have to renegotiate the date. There's no real reason or incentive to do that with dedicated locator. So just before we wrap up here, I know Kim will take the opportunity just to save the questions and get ready for the closing of the webinar. I just want to emphasize some of the key points we've covered. First off, thank you for your participation and thank you for your continued interest. When we did the Bill 93 webinar, we had over 1,000 participants. We've had more than 1,000 registered for today as well. So it's really positive to see such a high level of engagement in some of the positive changes that are coming to the industry. On behalf of the DL Working Committee, I want to thank you as well. As you've seen, we have some good and clear directions about how we think things should unfold in the near future, but we're also very interested in your feedback and very open to areas where we can improve and focus. So your feedback is very important. The working committee is very desiring of your input as well. So this is a very genuine opportunity to help shape the directions we go in as well. In the future, what's going to happen next? Of course, you'll all complete feedback by May 20th, and within your organizations, discuss these concepts in those documents as well. The committee will meet again in late May, and we'll think about some next steps. I would very much imagine that the next steps would include future webinars. And I imagine the focus of those webinars will likely be more, how can I put it, more sort of business matchmaking, more opportunities to dig deeper in terms of what kind of dedicated locators opportunities are out there, and maybe start to sketch out what some initial DL projects would look like in 2022, 2023. So I think collectively we'll have lots of opportunity to discuss opportunities and ideas further. So please think of this as the start of a dialogue and not the end of a dialogue. So thank you for your participation. Thank you for the feedback you're providing. And we look forward to talking to you in the very near future. With that, I'll bring it to a close. And Kim, I'll invite you to shut the presentation down. Thank you again.